Hi guys, Attorney Brianna Robertson here, and I just want to take a moment to talk to you guys about the whole trial and litigation process if you get charged with a crime and you're dealing with criminal charges. So, usually if you get to that point, that means that somebody's been reported a crime, or the police have, stopped you or charged you with a crime after a police investigation, and they believe that they have enough evidence to show that you actually committed this crime. So at this point, then they either will get an arrest warrant to arrest you, or they will arrest you and file an affidavit of probable cause on why you should remain arrested, or they'll give you a summons to appear in court for an arraignment date. How each state does this process is very different, but usually at this point is when, the police have done an investigation and they have decided that they have enough evidence of probable cause to charge you with a crime, in which case they will then charge you with a crime. And then once that happens, then the case then goes to the district attorney's office. Once the case goes to the district attorney's office, the district attorney usually they usually look at the police officer's whole case file, and they will decide whether they're going to officially charge you with a crime or not. And just because the police officers charge you with a crime, that doesn't mean that that's the charge that the DA's office is going to choose, because ultimately it's the DA's office that chooses what they're going to bring charges. They could add additional charges, they could have higher charges, or they could reduce the charges or bring no charges at all. But whether the charges are going to be brought is strictly up to the district attorney's office. And the district attorney's office, depending on the state, determines, how much time they have to bring the charges. But they do have a time period that they have to bring charges against you. Usually, I know, like in the state of Louisiana, if they don't bring charges within a certain time frame, your attorneys can file a motion that will release all of your bond obligations. But just because this happens, that doesn't mean that they can't still bring the charges, because there is still a certain time frame that they have to actually initiate prosecution against you. So if they decide not to bring the charges, then it stops there. They're not bringing charges against you and you're done. But if the DA's office does decide to bring charges against you, this is when things are serious before, but if they decide to go forward with charges, then that's when things really get serious. And if you don't have an attorney by this point, you definitely want to make sure you get one, or an attorney is going to be appointed for you, because this is when you really need to start defending yourself. Because if the DA's office decides to bring charges against you, you then will be set for a hearing, which is called an arraignment. And this is the time when the DA's office will read out the charges that they're bringing against you. And this is the time when you're going to plead whether you're going to plead guilty or not guilty to these charges. Any attorney that you get is going to recommend that you plead not guilty, especially at this point, because at this point, you don't know what evidence or anything they have against you. You don't know what defenses that you may have, because you have no information at this point except for except for the charges that they're bringing. So at this point, at an arraignment, your attorney is going to recommend that you plead not guilty, and you're normally going to plead not guilty at this point. In which case, every court is different how they align things at this point. Once you plead not guilty, your attorney can ask for a motions date, a status date, or whatever, however those courts work. But after you plead not guilty, the next step is that your attorney is going to want to request discovery. What discovery is pretty much your attorney is requesting from the DA that they turn over all the evidence that they have against you that's supposed to prove your guilt. So you want to know all the evidence they have. You want all the police reports. You want all the witness statements. You want every video, every tape statement. You want all the lab reports. You want every piece of evidence that they say they have against you that you can legally get. Because you want to know, they're going to accuse you of this stuff. You want to know what evidence that they have. And then this, like I said, this is the most important part in the whole litigation process, because once you figure out what evidence they have and it's turned over to your attorney, this then gives your attorney an opportunity to look through all of the evidence, because a lot of times, a lot of cases can be won through this discovery phase. because then it gives your attorney a chance to look through all of the evidence, to look through all the police reports, to watch all of the videos and all the statements, listen to all the statements that they have against you. And if your attorney, once we look through this, you can see if any of this evidence was obtained illegally, meaning were any of your rights violated, were any constitutional rights violated? Is there any evidentiary grounds that would not allow this evidence to come in? Do they not have certain witnesses? This is the time that allows your attorney to find out what evidence they're going to challenge and to bring motions on your behalf, such as motions to suppress, to keep that evidence out, that so they can't use it against you. And so that is why the discovery phase is so important, because this is the time when your attorney is able to look through this to determine if there's any motions that they can file to keep certain evidence out. This is also the time that we can figure out, what arguments that the district attorney is going to make, and then allows you to do in the investigation on your behalf. Make sure you're getting the witnesses that you need to test, the witnesses that you need that you may want to put on a trial as well. Do remember that as a defendant, you are not required to put any witnesses on or to testify at trial, because it is the DA who is the one who has the burden of proving guilt. It is not your job to prove, your guilt or innocence, because you are innocent until proven guilty. It is the DA's job to prove, they have the burden to prove the guilt. And so you're not required to have witnesses or to testify. But if you have witnesses on your behalf that you would like to put on the stand, this is the time to start interviewing, so that way we have witnesses to be able to defend yourself against allegations that the DA's office are going to try to bring against you. So after you've done the discovery process and we find out the evidence they have, the next step is when you start filing motions. Like I said, this is a time where your attorney can start filing motions to suppress, and also things that we call like motions to eliminate, which is dealing with like evidentiary issues and things like that to try to prepare for going to trial. You can also have, like I know the state of Louisiana, we have preliminary examinations where we have probable cause hearings to see what evidence, to see if they even have probable cause, and other preliminary hearings as well that we have in place that we can have before your trial. But usually that happens after the discovery process, is when you have motions, which is when you guys are fighting over evidentiary issues and evidentiary issues on what should be allowed in a case and which shouldn't. Usually around this time when you're dealing with motions, it's also when the DA's office, if they're going to give a plea offer, it's usually during this time. Do know that if the DA's office gives a plea offer, you are not obligated to take a plea offer. It is your right to go to trial, even though they will try to pressure you into a plea offer. There are some cases where your attorney might recommend that you take a plea offer, but these are things that are fact specific and case specific, in which you need to talk to your attorney about the specific facts of your case and whether that is actually the best option for you. But like I said, during the motions process is usually when a DA is going to try to give a plea offer to determine whether they want to take a plea or not. So after all motions have been had and, all plea offers have been denied, at this point is when you start getting ready to go to trial. And it is at the trial process where, the DA's office is going to have to put on all of the evidence before either the judge or jury, depending on what type of case you have, because every state is different on how they determine what cases goes before a judge, what cases go before a jury. In some states, only certain cases have a jury, and others, some types of crimes only go before a judge. So that's very state specific, in which you need to look at your state laws for that. But at trial, it's at the time where the district attorney's office will have to put on all the evidence that they have against you, where their witnesses are going to have to testify, and you have a right to have your attorney cross-examine those witnesses. And this is also a time where you will be putting on your evidence as well. And so then at the conclusion of the trial is when your guilt or innocence is going to be determined. Now, that whole process could take a very long time depending on the crime. the higher the crime, usually the longer the process can take. So just be in, a lot of times you don't really want to, a lot of times time can work in your favor as a defendant depending on the circumstance. Not so much if you are stuck, or you or your family member stuck in jail. You kind of want to get things moving as quickly as possible because you don't want somebody just sitting in jail waiting for the trial date, which happens often. But this whole litigation process can be rather lengthy, depending on especially the higher the grade of the crime, usually the longer it takes. But that is usually the litigation process in a nutshell. There are things that can happen after trial, but for the most part, that is the process that's going to happen, and that your attorney goes through whenever you hire an attorney. I hope this truly helps you understand the whole litigation process when it comes to prosecuting a criminal trial, a criminal charge, and what to expect if you or a loved one is charged with a crime. As usual, if you or a loved one is charged with a crime, you want to make sure that you have an attorney to help you, because at this point, if you're charged with a crime, your life is on the line, and you definitely want to have an attorney there to defend you. If your loved one is dealing with the crime, please feel free to contact my office at the law office of Brianna C. Robertson at bcrobertsonlaw.com, or you can call us at 504-517-5320, and we are here happy and ready to defend your rights. Thanks.